time is 7:01. Welcome to this meeting of the Wooddale Community Development Commission. My name is Jamie Ochoa. I am the chairman for the Wooddale Community Development Commission, and we'll get this meeting going. Marilyn, can you please do a roll call?
Yes. Mr. Ochoa.
Here.
Mr. Babowis.
Here.
Mr. Peterson. Here. Mr. Shemanek is not here. Mr. Surma.
Here.
Ms. Zadko.
Here.
And Mr. Woods.
Here.
All right, the CDC has a quorum present. First thing we need to do is we need a motion to approve the minute meetings from April 18, 2022.
I'll make that motion. I'll second.
Okay, there being a motion and a second, all in favor signify by saying yes.
Yes.
All those opposed signify by stating no. Motion carries. The minutes are approved. Moving on to the public hearing for tonight. Mr. Conway, as chairman, can you please do us the honor of facilitating this meeting?
Yes, Mr. Chairman. For our public hearings, all testimony will be given under oath. At the hearing, there'll be an opportunity for the public to offer testimony and to comment. Following the public hearing, the CDC's deliberations will be open to the public in the sense that all are invited to listen and to watch. The public, however, may not speak during the CDC's deliberations. Please be advised that this is a formal legal proceeding that is being recorded. The city's representatives will provide a general description of the proposal followed by their analysis. With respect to others who wish to speak, you may give an opinion or present specific evidence regarding this matter. Prior to making any statements, kindly approach the podium and speak into the microphone. Finally, we'll strictly adhere to the schedule prepared for tonight's hearing. However, those wishing to submit evidence and testimony will be afforded sufficient time within which to do so. Whether you're a member of the public wishing to make a statement for the record or a testifying witness, you'll be placed under oath and begin by stating your name and address. You'll be subject to questions by the Community Development Commission and potential cross-examination. To allow as many people to be heard as possible, we request that you limit your remarks to 5 minutes. Okay, well, recall tonight's matter, which is CDC 2022-02. This case was continued from April 18th, 2022, and involves the City of Wooddale's proposal for a comprehensive rewrite of the Unified Development Ordinance, Chapter 17 of the Wooddale Municipal Code, and a map amendment rezoning of properties located in the city. As you may recall, at the last meeting, the CDC reviewed and held the public hearing on Articles 1, 2, 3, 4, and 7 of the proposed UDO. Tonight, the CDC is scheduled to review the remaining Articles 5, 6, 8, 9, 10, and 11, and to receive testimony and comment on these remaining articles of the proposed UDO. Once the public hearing is closed, the CDC will proceed to deliberations and its recommendations. As you may recall, at the last meeting, the CDC requested that the city's consultants provide written responses to written objections that were submitted on behalf of certain property owners. The city's consultants provided the requested responses, and they are in your packets. Prior to proceeding to the article review, does any member of the CDC have any follow-up questions regarding the written responses provided by the city's consultants? Okay. No questions, further questions on the consultants' responses. Let's proceed to review of the articles. The first article that's up for review tonight is Article 5. That's off-street parking and loading. And that begins on page 154 of the draft rewrite. Are there any questions that any members of the CDC has for the consultants or staff on Article 5? No? Okay, let's proceed to Article 6. Article 6 is landscape and tree preservation. That begins on page 172 of the proposed rewrite. Are there any questions for the consultants or staff on Article 6? Okay, we'll move on to Article 8. Article 8 is subdivision plats and procedures and subdivision improvement requirements and standards. Begins on page 193 of the proposed rewrite. Are there any questions on Article 8 from the CDC members? Okay, moving on to Article 9, performance standards. Begins on page 225 of the proposed UDO rewrite. Are there any questions for staff or the consultants on Article 9 from the CDC members? Okay, moving on to Article 10, design guidelines. It starts on page 228 of the proposed rewrite. Any questions as to Article 10? Okay, moving on to Article 11, zoning administration, enforcement, and penalties, starts on page 239. Are there any questions on Article 11 from the CDC members, staff, or the city's consultants? Okay, so at this point, what I'm going to do is I'm going to open it up to members of the public. Now, what we're commenting on and taking testimony from you on tonight are these specific articles. So is there any member of the general public in attendance who wishes to make a comment as to any of these articles, Article 5, 6, 8, 9, or 10? Oh, Mr. Subak.
For the record, my name is Marshall Subak, S-U-B-A-C-H. I represent multiple property owners along Potter Street. My address is 168 South Central Avenue in Wooddale. Also, my office is at 1035 South York Road in Bensonville. I have specific objections that I emailed over to Gosha over the weekend. I'd like to pass out. Is that okay?
Yes.
And also, Sean, I know you don't want to limit it to these sections right now, but will we have a chance to give like a closing argument? Because the attorney and the consultant did a memorandum, which I got a copy of, and I per your request, I narrowed down on behalf of my clients what my main objections were, and I'd like to be able to present those to the board if they can give me that opportunity.
Yeah, so if you have a specific response to the Ansel Glink memorandum, is that what you're referring to?
I do, yes.
Yeah, then we'll allow time for specific responses.
And do you want me to do that at the end?
Yeah, why don't we take care of these articles first and then...
Sure. So now, if I can approach?
Yep.
Thank you.
Thank you. Gosha, you have her.
Yeah, that's the same, yeah. It is.
These, I don't have as many objections as I did before, but there's a couple as to Potter Street on the off-street parking and loading. On page 154, as drafted, 17501B3A, it talks about new uses or expansions of existing buildings. I'm okay, I have no problem with expansion of an existing building, but as drafted right now, it says that when a new use comes in to an existing building, you have to meet the parking requirements as required by this new UDO. And so that would be a change in the use, would be a change in, I'm assuming, if we went from automotive to monument sales, we actually got a monument sales person to come in there, we now have to meet the parking requirements of the UDO as revised, and we can't. We know that already, because there's not adequate parking over there. There never has been since it was originally designed. We have some of the property owners have a license agreement with the city that deals with parking on the right-of-way and requiring the property owners to maintain that parking. So, and I wouldn't expect the consultant and the attorney to know all that back information, but every time if we change a use, we're gonna have to meet the current parking requirements, and that's just gonna be an issue. So I don't know if the consultant has any suggestion of how to fix that, or if that is fixable.
Thank you. First of all, I would just point out that the requirement that Mr. Subak points out is a citywide thing. It's not specifically to the C3, and it's intended to keep there from being new parking problems where others may arise. To the extent that it's an issue for a unique situation, that's an opportunity that very often is quite reasonable for a variation or to seek relief from the city. And since the city has been involved in trying to address the issues, it would seem that there would be some understanding as to the issue that's there.
One thing, if I may add, that is also in our existing UDO, so that is not a change. It does say whenever an existing use of a building or structure shall be changed hereafter to a new use, parking and loading facilities shall be provided as required for such new use. That is from the existing UDO.
So it's a little bit of a harsh, and I didn't even know that was in the existing UDO. We never got like a red line, so if we're gonna fix stuff, to me, I'm saying, hey, let's fix it the right way. So that's an issue. On page 154, under 17502A1, it talks about parking and loading design plan required. I don't know if this is new or if this is existing, but it says in order to obtain a certificate of occupancy, you need to submit this parking plan. And again, I don't think, at least for the properties along Potter Street, they're going to meet any of those parking design requirements. On page 155, section 17502A2E, it talks about curbing, and that the way I read this is the parking lot design plan needs continuous concrete barrier curbing, a minimum of 16 to 18 inches along the perimeter of all loading or parking areas.
That is also an existing requirement.
Right. And that's also an existing deficiency that we don't have along Potter Street, and it's never been enforced. And so now when we see this in direction to what's being adopted, what can happen is if my client goes in for a permit for occupancy for a new user, they can enforce these regulations, and they're not going to be able to rent those buildings out. So maybe we need to fix under the grandfather clause that existing conditions are not going to be affected by this. But as drafted, I believe Mr. Silverman would, I don't know if Mr. Silverman has an opinion. Does the grandfather clause apply to this existing conditions, or would they have to come up to code?
You would have to, you can avail yourself of the non-conforming provisions of the code in this instance. It would be, it comes out of the zoning code. It is designed to protect properties that may fall into non-conformity. It sounds like this has been an issue already because this is an existing standard. So yeah, you'd be able to remain in place as is.
Okay. As long as we can remain in place as is, I'm fine with that. On page 156, subparagraph 8, it talks about yards. And I'm not sure how this would apply, but it says that off-street parking should be located in the rear. Again, all of our parking is on the front. It says no parking may be within 20 feet of a residential district. We're within 20 feet of a residential district because it's across the street. And it also says that off-street parking must be located, if it's in the front or corner yard, no closer than 8 feet to the front lot line. We can't meet those requirements. And Goshen, is that an existing?
I think ultimately it is existing. Right now, the code says that parking should be on the side or in the rear. Yes.
Okay.
So similar, non-conforming.
So would Mr. Silverman agree that if we're non-conforming now, we're legal non-conforming and that stays?
Yes.
And then upon the sale of the property, we're gonna fix
Yes.
that as well? All right, thank you. On page 166, for the table, it talks about contractors' offices, 4 spaces per 1,000 for parking. I'm requesting that be 2 spaces per 1,000. Even if the code prior had 4 parking spaces per 1,000 of office space. A lot of people now are working remotely. There's also, we're just creating too many non-conformities. I would rather have the business be able to meet the code than to be short every time on parking. So I don't know where the 4 per 1,000 square feet, has Mr. Baloo seen other communities have a lesser standard of maybe 2 per 1,000?
Yeah, it runs the gamut. I did a little bit of research, and I couldn't find anything that was specifically 2. But I would just let the commission know a couple of things. One is that this is not specifically a C3 issue, right? The parking standards apply across the community. So again, if there's an existing condition, then that's one thing. The other thing about the parking standard is that there's flexibility in applying those through the relief process. What we would typically suggest is that if you've got experience with how many parking spaces you actually need for that kind of use, that's a good reason to do one of 2 things. One is to revise the code if an applicant comes before with a suggestion, or to grant relief if there's a site-specific variation. But I hear what you're saying about parking changing.
Right. I mean, I know for the Household International building that now got torn down, they could never meet the parking requirements for office space. And that was one of the reasons that building stayed vacant for so long, is because they didn't meet the parking requirements for office. So it's those type of things where just making sure that staff is aware of what the code, what the reality is out there. And then going to the performance standards, if you go to section, it's Article 9, I apologize, I didn't put the page number. It was a late Sunday morning. 17,902,
It's 225.
page 225, thank you. In the 17902A, it says, no use permitted in any manufacturing or commercial. I don't think we have a manufacturing district anymore.
That should be industrial. I appreciate you
Yeah.
catching that.
So you guys can strike that and make that industrial.
Thank you.
So, Sean, that's all I have is this.
Okay.
I still would like to do a close and summary of the other issues.
Yeah, let me see if we have any more comment on these
Okay.
particular articles.
Can I just ask Goshen, do you have a lot of people that are not able to meet that parking of 4 spaces per 1,000 square feet?
It really depends. A lot of the businesses are existing, so if there is no change in use, we don't necessarily look at parking requirements. When the new use comes in, that's when we look at parking. Personally, I cannot recall a lot of contractor's office coming through where we would have to look at that, but we also do a combination. The office is a defined size, but then there could be a warehouse and storage, and that gets calculated at a different rate.
Right.
So usually, I cannot recall any instances from the top of my head, but one thing that is a change in the existing UDO, the current code we have right now does not allow an applicant an option to vary the number of required parking spaces. That was not listed as one of the authorized variations. That is one of the changes we're making. Under the new regulations, if there is an instance where somebody is not able to meet the parking requirements and they have a particular reason, a hardship for it, they have the ability to come in front of CDC and City Council to ask for that variation. Under the existing regulation, they cannot.
But again, so the record's clear, any building anywhere in the city that has existing parking, they come in with a new use, and they need a certificate of occupancy before they can get use. If they don't meet the parking requirements, they're not gonna have to go through the parking variance, not gonna have to get a variance because they're grandfathered in.
If the use remains the same.
Right.
If there's a change in use, then we have to look at the
Absolutely.
requirements. Yes,
Okay.
yes, if there's a continuous, yes.
Okay, thank you.
Okay, is there any other member of the public who has questions or a statement specifically as to Articles 5, 6, 8, 9, 10, and 11, which are under review tonight? Sir, go ahead.
I have your card. Yes.
Good evening, Commissioners. Carl Kimalucci from the Taft Law Firm in Chicago. Represent Gullo International, which owns a number of properties in the proposed TIO. Like Mr. Subach, I have some comments and responses to the memo that was provided by Ansel Glink, which I'd be happy to make later if that's more appropriate. In the meantime, I just wanted to follow up on one of the issues that Marshall was discussing. You know, a number of the off-street parking requirements, it sounds like properties would be able to continue with their existing parking so long as they were a legal non-conforming use. And in the last hearing, when we talked about some of the other, or at the last session of this hearing, when we talked about some of the other provisions of the code, legal non-conforming use came up a lot. And so I just wanted to ask Mr. Silverman about the process for asserting a legal nonconformity, because it sounds like a lot of property owners in the city may need to rely on their legal nonconforming status moving forward. So Mr. Silverman, could you tell us how, under the proposed UDO, if a property owner wished to assert that its property was legal non-conforming as to some aspect of the new UDO, they would go about doing that?
Yeah, it is the responsibility of the property owner to assert the right to avail themselves of the protections of the non-conforming use provisions by providing evidence that the property predates the code changes. And the UDO itself gets into the type of records that could in fact go to that proof, and this is submitted to the development administrator. Give me a second. Get back to
188. 188.
188. Yeah, so in 17702 of the draft code, that lays out how a property owner can prove that their property is subject to the non-conforming provisions of the code. Among the documents that could be submitted, building permits, lawfully recorded plats, aerial photographs, owned by the city and other official government records that indicated lawful establishment of the lot structure use constitute conclusive evidence of non-conforming status. And then there's a number of other things that are listed there, utility bills, leasing records, things like that, that can also be submitted to the development administrator to prove the non-conforming status.
Okay, so procedurally, the property owners say they had building permits and other evidence that their use was lawfully established before the change in the ordinance. They submit that to the development administrator, and then what happens?
Development administrator will then create a record of the building's non-conforming status.
Okay.
And Gosha, you might be able to speak better to what the city currently does in this regard.
It's a process that we're working on. Right now, there is a record that we keep, but usually there's communication back and forth between the applicant.
Okay, and so if an applicant were to have the type of evidence that the code identifies as conclusive evidence, then presumably the property owner would have met its burden and the development administrator would deem the property to be legal non-conforming?
Yes, this is an affirmative obligation on the development administrator. If a property owner brings in the types of evidence that we say is conclusive, it is conclusive.
Okay. And are you aware of whether this section has been changed at all from the existing UDO?
I believe it's the same.
I can check, I don't remember.
It's at least very similar, if not exact.
Give us a second, sorry.
Thank you.
17303. Maybe 302, 17302. Yeah, professional registration utility, yeah.
17.7,
17.302.
is it in there?
Yes, and professional licenses, utility records, it looks like the number of items are the same.
Do we have the conclusive evidence listed?
Yes,
Yeah,
conclusive
okay, so yeah,
evidence.
that was-
Mhm.
Okay. And so presumably the same interpretation would apply under the existing UDO, that would be an affirmative obligation of the development administrator to deem it used to be legal non-conforming if presented with that kind of,
If we were city attorney, yes.
okay. All right. Thank you very much. Nothing further from me, but I would like to come back when it's time to address some of the comments from the memo. Thank you.
Okay, is there any other member of the public who has a comment or a statement as to these specific articles?
Any one of those that's up there?
Correct.
Okay.
Yeah. No, no.
Hi, I'm Carrie Civicus, and I have the 229 North Central property. And actually, I did have some other things I was going to hand out some things and talk about some other things, but I guess this is what we're going to talk about. So I do have a few questions, and I appreciate the trees, okay? So under the article regarding the landscape and tree preservation, I have a beautiful maple tree on our property. And we've always tried to maintain our property. We're not doing a lot. We do gardens and things like that. The only concern I have is now, and I never had to really delve into all of this until these changes, but I guess there's going to be a rule where with the tree, and I think ours is bigger than 30 inches. So with the tree preservation, I believe there's a rule that if the tree has to be taken down or moved because of new construction, so again, I'm going to say, I'm going to keep my building, and I'm looking in the future. Now somebody's going to come in and want to change because of the change in the zoning. There's a tree right like in the middle of the property. So my question is, as I read this, we're going to have to do, I believe, 6 trees to our 1 or 10 trees to our 1 because of the size. but I don't know that that would fit on the property. So for a 30-inch tree or greater, yes, it's a number of 10 trees that you have to put on the property. So that would be one of the questions that I would have on how that would work. So I don't know if somebody has an answer to that, or is it something that's concerning to somebody?
The code's got has an alternative, that there's a fee in lieu, so that if it's, and it's not unreasonable to expect that if there's a large tree or even a couple of mid-sized trees, that you gotta put in a bunch of other trees.
Okay,
You can't kind of squeeze them all in, right? They won't even thrive.
right.
Right, so there's an alternative that the city can set an amount that you can pay a fee in lieu as opposed to having to replace all those, or provide all that replacement.
Okay. All right. And the reason I'm bringing that up is because I feel like my property, because of this change in the zoning, that's what people are gonna have to do, is tear my building down to make it what you guys are looking to do. And really, it's sort of a beautiful tree. It's right in the middle of the property, and my preference would be to keep the zoning what it is and leave the tree and let the next buyer, whatever, use it for what it is. So, but that would be my one comment, so.
Okay. Thank you very much. Are there any other members of the public who have any specific comments or questions as to these particular articles? Okay. So now what we'll do is we will turn to the memorandum that was submitted by the city's consultant, Ansel Glenk. And that was in the city's posting. It's noted as Exhibit A. Are there any members of the public who have a question or statement about the memorandum provided by Ansel Glenk? Mr. Subak.
Can I approach you again? I have more handouts.
Sure.
Are you making these all submitted into the record?
Yes.
Thank you.
Again, Marshall Subak, S-U-B-A-C-H, on behalf of the Potter Street, as well as myself as a resident of Wooddale. Trying to just, what I passed out to you is, the city attorney asked me to kind of summarize what I'm calling my key objections as to Potter Street. And some of the objections I made in my first letters were just overall as to issues I saw as I read through the 260 or 280 pages, whatever it was, a couple times. Some of those are less important. So some of the responses from Mr. Silverman, I'm okay with, and I'll let go. So, on his memorandum, page 1, calling it regulations versus internal procedures or processes. What I was looking for there is I just didn't want to go through this entire process, and no disrespect to Gosha, but whoever's sitting in that place in the future, I didn't want staff adopting further. When I read regulations, that's a buzzword for me, that those are obligations. And so I'm fine if they want to call it internal processes or call it procedural regulations, whatever it is okay with me. I had a little problem with the word regulations. As Ansel Glink has explained it, that's fine. Gosha, do you care which way it says?
No.
So either way, okay? On page, objection number 2, page 36, striking the 90 days limitations. I deal with a lot of zoning cases, and so I was trying to give a little bit more authority to Gosha in granting extensions, but I'll withdraw that objection. If you want to leave it at, she can grant 90 days extensions, that's fine, so I'll withdraw that objection. Page 37, again, I was trying to protect staff, because there's, at times, city councils can be overbearing on staff. Not our city council, but in previous years. And so I was trying to say that instead of having it say will, or, you know, it may, but I'll strike that objection, and it'll just be an obligation of staff to do that. I didn't like the word punish in the UDO, and so I'm okay if we substitute that out and say penalize as far as violations. Punish is such a harsh word. The next objection reply was number 4. I'll withdraw that objection. Page 5, I was actually trying to help this board, believe it or not. Right now, as drafted, you need a majority of the entire board to pass something. I was suggesting just a majority of the quorum that appears for a meeting. Mr. Silverman recommends and Mr. Blue recommends have it be majority of the entire board. That's fine. So I'll withdraw that objection as well. The next one, number 7, I'll withdraw that objection as well. That's recoverable cost. I'm just trying to make it not too overly burdensome for developers and business owners when they have to apply for zoning relief, but I'll withdraw that objection. We just hope those costs are reasonable. Page 44, sorry. Well, that was paragraph 6. So this is a good one. This one automatically exempts other public entities from the fees on a development. So if the Wooddale Park District comes in for a development, this automatically exempts them from fees. The attorney says that's a policy decision. I agree with that. Some residents in Ward 1 are, Mr. Babowitz, I don't think you're a member of the Wooddale Park District, right? You're
That's correct.
Bensonville Park
Bensonville,
District.
that's
So as a taxpayer, it wouldn't really be fair to automatically waive it. I'm not saying you can't waive it, but I would say doesn't affect the people on Potter Street. You guys aren't getting billed for this time right now, but the exemption should not be automatic. It should be on a case-by-case basis. It's the same thing with the library districts and all that. Number 9, I'll withdraw my objection. 10, I'm okay with withdrawing my objection. Same thing on number 11. Number 12, page 50, it talks about for site plan approval. There's a lot of times when you read this carefully, what is required for a site plan approval. And this now requires topographical surveys, tree survey, and soil conditions, a soil test. That's just for a site plan. So that's a heavy burden on a developer. If it's a new development, yeah, that's okay. But maybe I'm reading that wrong, Mr. Blue. I guess.
That one's on page 50?
Yeah, that's paragraph 7I. Or yeah. Applications for site plan approval. Maybe the solution is just allowing staff to waive any of these requirements if they deem them not necessary. So I have enough confidence in Gosha, wherever sitting in her seat, that if she doesn't need a soil test, she's not going to tell the developer, hey, you have to get a soil test for every site plan.
That's what we were checking, but yeah, that change would make sense, yes.
Okay, thank you. Not thank you as I'm done, but thank you for that. Next one is on, this is number 13. It talks about the notice, all right? So I know the steering committee had in their minutes that they wanted to get rid of the 250-foot notice on a development. I think that's not a good idea. I think that it should stay, give notice to all the property owners within 250 feet, put the sign up, like they didn't do on this one. And also, if you're going to, and the attorney's writing his memo, if you change the zoning, you have to give notice to the landowner. But as you can see by this UDO use table, you could change the use table without changing the zoning. So you could pass all this, and then a month later, the city council could amend that UDO and give no notice to the Potter Street residents or the people on Irving Park Road and change their permitted uses. It's almost the same as changing the zoning. And so what I was asking for is make it open and transparent. If you have a new development, notice within 250 feet, and if the city council or this board changes the use, the permitted use, special use, or tries to amortize out a use in the future, give notice to that property owner so they can come in and say why it's a bad idea. You can still do it, but just give them notice. Transparency with government really, really helps. And if you don't have it in there, I know Mr. Silverman said it would expand the notice and expand cost. We're going to charge the applicant to reimburse for attorney time, reimburse for consultants. Let the applicant pay a little bit more to send the notices out through staff. We can compensate for that, but give the surrounding property owners, and if the city changed the UDO, darn it, give notice to those people that it's affected. What are we scared of? You know, tell the businesses what are going on. So that's my first one for my key objections. That's number one on the handout.
I just want to, we were looking for the administrative discretion provisions on the previous item in terms of waiving submittal requirements. The section you're referring to is the minimum submittal requirements for any kind of application. Item 11 on page 51 is the administrative discretion, and it says, notwithstanding anything to the contrary in this article, the development administrator or the community development commission may waive any application requirements otherwise set forth in this section where the applicant demonstrates to the satisfaction of the development administrator or CDC that the information required is not relevant or necessary to the determination. So that is in there, and it applies to any of those applications.
All right, perfect. Thank you. So as a formality, I'll withdraw the objection. Thank you for the clarification, Mr. Silverman. So I'll withdraw the objection as to number 12 on page 50. The attorney in the memo didn't, it is a policy decision on who you guys give notice to. So I would say lean towards more notice than less. The worst thing you'll get is some people at least know what's going on and speaking their objections as to that. Coach, is it hard to give notice to 250 people in the area?
I think we mentioned the last time, it's not hard, but sometimes the number of notices varies. It could be 50, it could be 500, depending if we have condos and how small or large the properties are. So it's not a hard thing, it's just more or less time consuming.
Any other questions on that for me or the attorneys? No? Okay. Next is the, on page 57, and these things, they do all tie together. On page 57, it talks about the standards for use interpretations. In subparagraph 5C, it says, no use interpretation will permit a use not already listed as a permitted or special use. So in this case, we're tying Gosha's hands, saying that if we come in and say, well, our use is just like this one, if it's not on the use table, it's prohibited. And this doesn't give her the authority to have any interpretation of, hey, this is really just like that use, go ahead and you can open. You have to go through the process. So I stand by striking number 5C, dealing with interpretation. Next is number 15. I had an objection about the 6 months. I can withdraw that limitation or objection, that's fine. Same thing on page 58, that a variance is good for 6 months. I think it should be 12 months. 6 months goes awfully fast. As far as, especially in these days, it just talks about getting a building permit within 6 months. These building permits are going to get a little bit harder because there's going to be more regulations to follow. We're going to have to get the soil test. We're going to have to get the topographical study. All those things are potentially take time. And if they're only good for 6 months, so I think the one in number 16, I think a year is not, it's very common that things last a year with municipal codes. Mr. Blue, are you okay with a year?
It's a policy decision. I mean, it's a matter of, on keeping the activity moving. So,
How did we come up with 6 months?
It's, I mean, the best answer I can give to that is it's standard in many zoning codes. You don't want relief to just sit out there unused. So, as we explained in our memo, the reasonable expectation is someone seeking the relief is ready to proceed with their project. This prevents that relief from just sitting out there being unused for an unreasonable amount of time. So 6 months is a number that is commonly used as a limitation on how long a granted variation is good for without pulling a building permit.
Have you seen a year?
Not to my recollection.
So they have to have a building permit within 6 months, not apply for it, actually have it in their hand?
Have it in their hand. And what's going to drive a lot of variations is construction documents that are already drawn that show that there's a problem.
Right.
So a lot of the work would have already been done, and it's not unreasonable to expect that that person can go in there and with those plans and apply for their building permit. I think it's important too to remember that the development administrator does have the authority to grant, I think it's a 90-day extension on any of these things with timelines. I can't remember what the exact time
It was
is.
90 days.
Yeah, 90 days.
Right,
So conceivably, you could go to 9 months.
right. The only thing I disagree with Mr. Silverman, a lot of times developers come forward with a site plan. They don't do engineering drawings, they don't do building permit drawings, they just do a site plan and they say, this is the great development we want to bring to Wooddale. It's got Starbucks, it's got an AT&T, it's got a 7-Eleven. They'll bring a site plan to you, not a full set of construction drawings. Gosha will say, hey, you need these variances in order to get this approval done. And if you grant the variances now, they've got to have a building permit in 6 months. 6 months, a year, it's your call.
I will
So-
only, I'm sorry, I will only add, the existing regulations state 6 months.
Your call. Number 17, I'll withdraw that objection. Number 18, I like Mr. Silverman's compromise of deleting the word narrowly. I'm okay with that.
Oh, you know what? I'm glad you brought that up.
Uh-oh.
The way I wrote that was awkward. We're advising, our advice would be not to change it at all. And here, narrowly is an important word in variations because you want to grant the minimum variation necessary to enable the property owner to achieve what they're trying to do. So the way I wrote it, I realized after I sent it that it could be interpreted that I'm suggesting that it's okay to remove narrowly. That's not well presented with how I wrote it here. So we would advise no change. But
Yeah, nothing I want to get bogged down on tonight, so that's up to you guys. On page 60, the authorized variations, I think they have expanded what variations the city council can do, but it's still a limited list. Other towns allow for a variation of anything. It's still up to the city council whether or not they want to adopt it or not. And I guess I would say trust your elected officials to decide. You don't want to tie their hands for a variation. I think I gave you this example before. I represented McDonald's when they opened up in Bensonville, and because of the drive-through and because of Bensonville's archaic sign code ordinances, back then, I think they fixed them, we needed like 36 variations on a sign code. And if we come across, this is all new, so why not give the city council the authority to grant any variances they want? Mr. Blue, is that really that's a policy decision, right?
It is a policy decision, and I've seen it both ways. You know, the idea is that there's some predictability. This is not just about property owners, it's about their neighbors, knowing the kinds of things that can be varied. But I don't know if you've seen it otherwise, but I have seen it both ways.
Next is the number 20, page 63. That's the 6 months with the 12 months. That's up to you guys. That's okay. Number 21, page 84, that's my key point. Number 4. This is something that it goes back to the permitted uses and the special uses. A permitted use is going to be a use that's allowed as of right, and a special use is something that the property owner or the tenant has to come through and get approval, or the developer has to get approval for, and it can't be denied. Right now, as drafted, it says if it's not a permitted use and it's not a special use, it's prohibited. And Gosha has no authority to interpret either way. So I'm urging this board, or this commission, to make sure that we have a good use table, because as drafted, it's prohibited. When Mr. Silverman explained it the first meeting we had here, he didn't think that's how it was originally drafted, and then as we went through it and read it again, and his memo clarifies, if it's not on the list, it's prohibited. That's a little bit, we don't have to do that. You can strike that. Number 22. This is on page 87. This is dealing with outside storage and some of the regulations. Yes, I want staff and you guys to regulate outside storage. We don't want outside storage to be a free-for-all. As far as Potter Street, you can definitely screen from Potter Street in the residential, which is important, and it's done primarily. To screen all the way around becomes a little bit more difficult. One, because you have the railroad right away. Two, a lot of those businesses have easements between them, and it's not going to allow for screening all the way around. C, the height, when they're talking about 8 feet, and I don't want people when they're driving on the train going to Itasca to look down and have it look like garbage. But Whether that fence is 6 feet or 8 feet, it's not gonna matter. The second story on that train is gonna be able to see in those backyards. The other issue we have is the railroad is now a quiet zone, so those horns don't go off. When you come up on Ash and you look down, see, even if the gates are up, most people still slow down and take a look. And if everybody has fences up along the back, you're gonna have some line of sight issues. So I would propose that, I'm not saying get rid of the screening entirely, but just have the screening be from Potter Street, maybe on a minimum of 2 sides or 3 sides, but not make it required to be all the way around.
All right, Mr. Subak, let's wrap this up in 5 minutes, okay?
You don't want my closing argument yet, though, right? This is just on the memo?
Yeah, we're not doing closing arguments. This is just for testimony only.
Okay. Well, I didn't know we were going to be limited on attend and time. So the next one is the table for C3 zoning says all the lots need to be at least 100 feet wide. All the lots over there are 50 feet wide. By adopting a 100-foot wide requirement, you're creating non-conforming lots. So you're going to hear testimony hopefully from other people today that says their lots are 50 feet wide. The zoning regulation for C3, which is so specific just for Potter, should be 50 feet wide. Otherwise, you're creating non-conforming lots. There's issues with not allowing for parking on the right-of-way because we have the license already in place. And then the section 17, this is my point number 10, 17-703C. There's some confusion on whether or not these non-conforming uses are going to run with the land. They should transfer if my client sells that piece of property. That non-conforming use should be subsequently given to that next property owner. And I think, Mr. Silverman, you were going to revise the language to provide for that?
Well, as I indicated in the memo, we agree with your interpretation of that section. I think I was getting confused with special uses and things like that, but certainly here, this, we agree with your interpretation. 17703C is pretty straightforward.
So then in your memo, it says subsequent lessees, it would be subsequent owners.
Well, right now, it's quite clear that it would go to a subsequent owner. We think clarification might be useful if CDC agrees that a subsequent lessee would be able to have the rights. It may be more belts and suspenders than anything else. It may be unnecessary, but for the purposes of clarity of the code, we could certainly add that.
And then, before I do a summary, I passed out uses. I sent them out twice, but the permitted uses, they left us 6. Tombstone sales, I don't need to go over those again. What we're asking is that we're allowed to do building services and supplies. And remember, there's already standards in place in the UDO as to how much light can come off these buildings, how much noise can come off these buildings, how much odors can come out of these buildings. Those are already regulations that the city has. So we're asking to be able to have building services and supplies, outside storage to a permitted use, uses which involve manufacture, processing, production, assembly, fabrication, and/or distribution of goods. That's, I think, in your current, the UDO right now. Office, administrative, and professional. Warehouse and distribution. That's very important for the C3. You're going to hear from tonight, there's a owner over there that his entire business in there, and the reason he bought the building is warehouse and distribution. So we think that should be a permitted use. Motor vehicle repair, motor vehicle services, printing establishments. The whole list here is all very reasonable and nothing obnoxious as far as uses. The memo from Mr. Silverman said, well, we can make those special uses. Special uses, you have to go through the process, and by that time, that tenant or that business could be long gone. They'll go to Bensonville, they'll go to Elk Grove, they'll go to Addison, they'll go to Itasca. As far as the special uses, we're willing to strike. I've heard some elected officials that there's a real problem with the recycling center. If you don't want the recycling center as a permitted use over there or a special use, we'll take it off as a special use. But the other ones, I think, I have not heard any problems when I go over this as to this, and that's a policy decision. It's not a decision for Mr. Silverman, it's not a decision for Mr. Blue, it's a policy decision. And the last thing I'll close with, the reason there's so much angst here is, again, these are people's property rights, and these are big changes. Mr. Blue, the first time he came here, he said, hey, this is what we wanted. We wanted public response. That's not what this is. This is a public hearing that they asked you to pass this as is with no amendments from that first meeting. It wasn't a public input meeting or community outlet meeting. It was a meeting asking you to pass this. So unless they're going to make these changes, I urge you to vote no. If you vote no, it's still going to go to the city council. But the nice thing is, with the no vote, city council has to get a supermajority, and that's going to force them to sit down and make sure some of these things that hopefully we brought to your attention, these are unintended consequences. I'm not saying Mr. Blue's out to get the businesses or Mr. Silverman or Gosha. These are just unintended consequences that when you make these massive changes that happen. And so we took the time to bring these to you. Not only do we say it's a problem, we gave you suggested changes, and we're just asking that those suggested changes get incorporated. We can't pass it and then figure out what's in it. I don't think still we know exactly what's in this thing. So I would ask you, if they're not going to incorporate these, I scaled my list way down to 11. If they can't put those 11 in there, vote it down, and at least the city council can negotiate and have to require a 6 supermajority in order to pass. And the last thing I'll say, as a resident, not on my client's dime, we have 2 pages of outside regulations for outside eating. Mr. Silverman in the memo said maybe Mr. Subak should come up with some suggestions. I don't know what the regulations should be for outdoor eating, but just knowing all the issues that the businesses have gone through in restaurants with the pandemic, with the shutdowns, I'm happy they're still around in Wooddale. I'm happy that they're there. I just don't want to overregulate them. I want them just to be businesses hopefully making money. The last thing I'll say is to Irving Park Road. If we're looking to get Irving Park Road redeveloped, I would say you could pass these changes with the rezoning as an overlay district. If it's passed as an overlay district, it would be an incentive for some of these larger businesses to come in and redevelop, but it wouldn't hurt any of the existing businesses that are there already. And they'd be able to continue to use their building, improve their buildings, and if somebody comes along later to take them out, it would be their choice, but they wouldn't be forced to. Thank you.
Okay, thank you, Mr. Subak. Is there anybody else who has any specific comment or question as to the Ansel Glink memo? Yes.
For the record, Carl Camalucci again, Taft Law Firm in Chicago, 111 East Wacker Drive. I just have a couple of responses and questions to Mr. Silverman's memo. The first having to do with notice. I know that memo addressed some of Mr. Subach's comments regarding the way notice is proposed to be handled under the revised UDO. And there was a sentence in the paragraph regarding the comments that I had previously submitted stating that notice had been addressed earlier in the memo, but I don't believe that the 2 comments that I had made about notice were addressed, the first being that no notice was posted on any of the properties that are subject to the rezoning, which is required by the current version of the UDO, and the second being that the revised UDO and the proposed zoning amendments were not made available to the public 15 days before the hearing at the same time as written notice and published notice was provided. So I just wanted to note that for the record. I believe Wooddale is a non-home rule municipality and therefore must comply with the requirements of its zoning ordinance, and so minimally those signs should have been posted on the property. I also was hoping to clarify, Mr. Silverman stated that all properties that will be located in the TIO will be removed from the TCC, the Thorndale Commercial Corridor. And I just wanted to confirm that that's the case. Is that true?
Yes.
Okay, because there's two figures in the revised UDO, figures 4-2 and 4-3. Those figures depict the properties that are located within each of those overlay districts, the TIO and the TCC, and they both appear to depict some of the same properties. So to the extent that it's intended that properties included in the TIO will be excluded from the TCC,
There's a revised.
it's been revised since the last meeting, is that what you're saying?
It's been revised. The properties that are in the TIO will not be in the TCC.
Okay, so that was a revision that was made in response to the comment, or that was always the way it was set forth in the revised UDO?
That was always the way it was anticipated. It was in the text that way, and the map was in error. I apologize.
Okay, thank you. Thank you for clarifying that. The last thing I wanted to respond to generally about the memo is, in many cases, the response from both Mr. Blue and Mr. Silberman to many of the comments that have been made is that, well, these are policy decisions, which is a way of saying that it's not up to them, and that's true. I agree with that. And it's important to realize that policy decisions are made in part by you as members of the commission. Now, you don't take final action on the UDO. You only make a recommendation to the city council, and the city council takes final action. But you are part of the policy-making process. And so all of these issues that have been raised, not just by me, but also by Mr. Subach and all of the other property owners who've appeared, and we've had a full night every night, a full room every night. You participate in the policy-making process by considering the UDO that's been presented to you and deciding whether or not you want to recommend approval of that UDO and send it to the city council for its approval, or whether you want to recommend disapproval and perhaps recommend to the city council that it be sent back to the UDO working group so that there can be more meaningful participation by local property owners and local developers in the process for coming up with some of these regulations. I think the number of people who've shown up here, what is this, our fourth night now? Every time, shows that people want to participate, and people were not able to participate at the time that these regulations were being prepared, and they have concerns about what's in it. So yes, they're policy decisions. You're part of that process for determining the policy decisions. And in your role as commissioners, you can recommend that the city council disapprove of this, not forever, but for the purpose of sending it back to the working group, involving more of these people, seeking their feedback, and improving this work product. We all understand that the city wants to foster redevelopment in the city, and redevelopment is a good thing. I represent developers in part for a living. It would be against my interest to say that development is a bad thing. Development is often a good thing, but it has to be done the right way, and it has to involve everybody. This UDO and the conversations we've been having remind me a little bit. Does anybody remember the movie Field of Dreams? It's a baseball movie. I don't know if anybody's seen it, but it's about this guy who hears voices that say, if you build it, they will come. And he builds a baseball field in the middle of a farm, and all these baseball players come and play a game. And I feel like a lot of what's behind this UDO is, if you zone it, they will come. But I don't think it works that way. Zoning alone cannot make a market for redevelopment, but it can break the market. The TIO is a perfect example of this. The TIO, by requiring 20-acre parcels, by requiring planned unit development for every new development, by making it difficult for property owners who have smaller parcels to sell their parcels to somebody else, because then they would have to assemble it, shrinking the market for those properties. It creates a perverse incentive for the current owners to hold on to those properties and use them as they're currently used for as long as possible, so that they don't get penalized in the market when they turn around and try to sell their property. So instead of incentivizing larger scale development within that area, ironically, these regulations will probably freeze up development in that area. If you zone it, they may not come. It doesn't make a market. It only breaks it. That's one of the reasons why we suggested incentivizing larger scale development rather than requiring it with the proverbial gun to the property owner's head. If you say, if you assemble a parcel of 20 acres or 10 acres or whatever the number is, we will allow you to build a bigger building or a denser building or get relief from some of the other requirements such as setbacks or parking or any other, there's lots of different approaches and ways that you can incentivize larger scale development. Then you open up the market to the current owners. More people will want to buy the property. More of those owners might be able to participate in the redevelopment. And that is a policy decision. It's a fundamental policy decision. It's a fundamental problem with the current regulations that you have an opportunity to participate in and change for the better. Because many of the regulations in the current UDO seem to put the current owners and local and smaller developers at a disadvantage compared to people from outside of the community and larger developers who could come in and take advantage of these regulations, and they're the only ones who could come in many cases and take advantage of these regulations. And so as a policy matter, do you want to encourage redevelopment that involves the participation of the people in this room? Do you want to encourage redevelopment that involves current owners and local developers? Or do you want to encourage redevelopment that excludes most of the people in this room to their detriment? That's a policy decision. It's embodied in this ordinance. You have the opportunity to participate and improve it. The goal of redevelopment is not bad, but it can be done better than it is right now. And so I encourage you to recommend disapproval of this version of the proposed UDO and recommend that the City Council send this back to the working group, involve these people, and improve it, and the city will be better for it. Thank you very much.
Is there anybody else who has a comment or statement as to the Ansel Glink memo? And sir, have you been previously sworn in? Okay. Marilyn, if we can.
Would you raise your right hand, please, and state your name and address?
Yeah, Brian Paul, 303 Potter.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yep, I do. My name is Brian Paul. We own a building, or I own a building at 333 Potter. I'm very late to this game. I'm taking a guess that the memo, what I'm going to speak to, and the questions I have refer to it. I just found out about this last week. I was given no notice. I have no idea why. I know if I had a zoning change and I had to come here, I would have to give notice. So to change the zoning in an entire town and not require notice, and for me not to even get it, and I am a property owner here, and it is, to me, is perplexing that it doesn't go both ways there. But I'm very late to the game here. I know nothing. I've done as much as I can to dive into what's happening here. Gosha was kind enough to give me an hour of her time the other day to walk me through a lot of this as well, so I do very much appreciate that. So I echo a lot of the statements. I don't even know all these gentlemen. I happen to know one for a month here, but I am not in part of that group. But I have what we do with our building, we have the nicest building on the street, in my opinion. We use it very quietly. We store cars in there. We have classic cars we store in there. We don't run a business out of there, and that's obviously not a very normal use. So the use that was applied to it when we bought this building in 2018 or 19, pre-pandemic, was warehousing, and I didn't even know that. So I'm talking to Gosha the other day. She did some homework on our behalf, and being that that is the use that's assigned to it, I'm currently a warehouse use. I'm no longer going to be conforming if you pass this in its current form. And reviewing as best as I could, and especially at the table that talks about the uses, I don't even know who generated all this, but it would seem whoever did generate the uses wants us to be Contractors Row, because that's the only use there that could possibly be here, doing it by rights and not a special use. I believe it was, unless Tombstone Manufacturing takes off in Wooddale, food prep, they're not going to do food prep here. Certainly not going to be office. If you look at the buildings there, unless you have to rebuild from the ground up, you can't possibly build anything that's even conforming to what's written there. So it makes sense. These are contractor's yard from whenever an automotive use leaves here, it's going to end up having to be a contractor's yard. From what I can see is the allowable use by right as opposed to a special use. So we recently bought the lot next door, and during the pandemic, and I was unaware of everything happening in the background here. I think we closed in mid-2021. So, and our intention was to add on to the building, just to be able to use it for its current use. I think we're very good neighbors there. Again, very quiet, don't use the parking there, but we wanted to expand the building. So we own a lot, can no longer expand the building there. I could sell it to a contractor and try to get out now. I could give it to a food prep company, but they can't possibly, I'd be changing the use there because now we're warehousing completely non-conforming anything. One of my questions I did have actually for that, I believe the gentleman at the table, is if we are set up for our current use and it is non-conforming and we sell it to someone else for the exact same use, can it carry through and is everything exempted in terms of non-conforming, being that it's not allowed in the zoning district anymore?
The non-conforming status goes with the property, so, yes.
So we can sell it, okay.
Based upon the scenario you just said, yes.
But the existing lot next door, we would not be able to expand upon it in terms of wanting to
Right.
continue that warehouse use there.
Right. As the regulations are drafted right now, you can't increase the intensity of the non-conforming use.
Okay,
So-
so I mean, that's pretty much what, from my understanding, and I'm in real estate, I do understand it. I go to plenty of these meetings. I haven't gotten too deep into the entire change throughout the whole town. I've tried to get into the I designation to the C3 designation, and a lot of the comments here tonight I agree with. It doesn't really apply to me and our specific use, but I do find it, I don't get over dramatic, but shocking about it that there's really no uses to a C3 anymore. There's none. That you can use on Potter. Other parts of town, I'm sure that you have wider lots, you can get the parking, you can do all sorts of things to it. But in terms of a lot of the rundown facilities, they're automotive. This is known as Automotive Road. I don't live in Wooddale. When I want to get a car fixed, though, I do want to come over to there because I know, and I brought many of my cars here over the years prior to even having a building here, because I know there's very good automotive use there, and that's where you go. So that's what's here. All these, the gentleman a moment ago said that people are going to hang on to their lots for as long as possible in their current condition. I don't know if it was applying to what we're using it for, or any of the guys on this street that you want to improve and save the neighbors across the street from having to look at this stuff. That is never going to happen because they can't transfer this to anyone that can use it. It's impossible. So if you want to get it fixed up over there, you're going to have to add uses on here that are in the spirit of what you're trying to achieve. I get it. It definitely doesn't look like it's the Gold Coast of Chicago on that street in terms of its current condition. If you want to improve it, you're going to have to take a step back, and really in this district, and I don't know if there's more C3 in other parts of town that are more applicable to, but unless you add more uses to this, you're going to have a real problem. It is going to get worse because they can't sell it when they need to. So, the last thing I had is when we did buy this building, it took us almost 4 months to get a permit for the work there. The people we were working with are no longer with the town anymore, so we may have been a staff issue at the time. But it was 4 months, and all we did, the existing building, we wanted to paint it. We added a fire sprinkler system just to improve it. We added, improved the plumbing, but didn't change anything inside in terms of the footprint. The outside was unchanged entirely. It took 4 months to get a permit. So the variance process, in terms of it being good for 6 months, and we might very well, if we're stuck having to figure out what to do next door and we need a variance, the confidence to get a permit in 6 months, from my own experience here, is something that really needs to be written into here, that unless it's the petitioner's fault in terms of getting a permit, you can't issue a permit, a true ground-up building permit in 6 months. it's not going to happen. So I think you're going to have a lot of people coming back looking for extensions there, unless there's some sort of leniency, more than the 3 months to Gosha's team, that allows for it. There is something that's outside of their control. I shouldn't say outside of their control, but something that they're in the process and everyone's working in good faith that they can get that continued in terms of the variances. And you can leave it to the discretion of staff. The staff's been great to work with. But if you don't have that written in there and it's an automatic redo, it's going to be a problem because, as the gentleman said, when we come in for new developments, we're not coming, especially large-scale developments, we're not coming in with design drawings. We're not going to do anything on we're not going to spend hundreds of thousands of dollars on design drawings until we know the variances at least we're going to get there and we have complete confidence and there's going to be no changes. That's a lot of money to lay out up in front. So we give, when we're looking for variances and preliminary approvals, we're giving what they're asking for to make sure we don't go the cart too far in front of the horse. And for us to design, and we do industrial construction, for us to design full industrial type product and get it through and work with your team to make sure it's what they want after the approvals that we're looking for up front, to get through that back and forth with you and get a building permit in this day and age is impossible in 6 months. So, that was just building that other back. So I highly encourage at least give discretion to Gosha's team in order to extend that beyond just a written 3 months, and you have to start over for a village board approval. So that's all I have. I appreciate it. I very much ask that you really look at the allowable uses. Unless you want all contractors and automotive there, it's all you're going to have between the existing automotive and the fact that we can flip these out to contractors, and I just don't see any other use given what's in the table right now. So thank you.
Thank you, sir.
Would you spell your last name, please?
Paul, the traditional Paul.
Thank you.
Okay, is there any other member of the public who has a comment specifically about the Ansel Glink memo? Yeah, we'll get to the memo and then. Okay.
Okay. Your name and address, please.
Kevin Shields, Shields,
Thank you.
367 East Potter.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. All right, I am the warehouse and distribution company that Mr. Subak referenced earlier. The name of our business is Sealmaster. We've been in Wooddale since 2008. We've had a great relationship with Wooddale. Wooddale has been an excellent location for us. When we looked to expanding into this area, we did some research on some of the neighboring towns, and we felt that Wooddale was going to be the most conducive to us being able to grow, and it has been. We've grown sales in this facility up to $2 million. It's grown every year for the last 8 years. We collect sales tax. I just did a quick look. Last year, we collected $133,000 in sales tax, so I look at our growth as being beneficial to the community as well because you get a portion of that back in sales tax. A couple of concerns that I have is, one, people have outlined the issue with the property value, and the limited number of uses is most likely going to limit the number of people that are interested in acquiring our property. But for us, what's more important is the value of our business. We own the business and we own the facility that we are operating out of, and the value of the business is significantly greater than the value of the property. And we have some very serious concerns if we become a non-conforming entity. And I know it's been said, but I just want to clarify because I'm a little bit slow. It sounds like the non-conforming entity will be granted, and that will be grandfathered with the property, even if there's a sale of ownership.
That's correct.
And then if I understand correctly, if it's a non-conforming entity, there is no ability to expand the existing operations.
That is correct.
And so as a growing company, you're basically saying that we should stop doing anything in the city, and I should go look to grow somewhere else to basically make the best use of our time. So it's a very polite way of saying, we don't want your business here, you should go look to grow somewhere else. And that's a serious concern for us. We've had opportunities to sell our business. It's based on the growth of our business, it's based on the value of our business, and this is basically incentivizing our company to say, we shouldn't be in Wooddale, we shouldn't invest any more money in Wooddale, because we're not going to be able to get the return on that at a future point in time. And I understand that. We are not what I would call a sexy business. We resell pavement maintenance products. We're very useful. We try to be clean. We try to be a good neighbor. But our goal is to continue to invest and to continue to grow. And if the village does not want us to do that here, it doesn't want our sales tax dollars, we understand that, but then there should be some sort of a compensation for a company like ours that has spent 14 years here so that we can move somewhere else to be able to continue our growth. And so I would ask that we consider including our use, which would be the warehouse and distribution, to be included with this, so that we're not forced to make a decision that I don't think helps the entire idea of what, in the spirit of what everybody wants to have done here. So that's all I have. Thanks.
Thank you, sir. Okay, anyone else who wishes to make a statement, comment about the Ansel Glank memo? Okay. Is there anybody in the audience tonight who has not yet had an opportunity to speak? Sir.
Would you raise your right hand, please? State your name and address.
Anthony Trotto, T-R-O-T-T-O, 138 West Irving Park Road.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Okay. Thank you. I want to thank you for your time. I know that you're volunteers. You're not making a lot of money here tonight, but I appreciate you listening to us. And I'm here today to ask you to vote no on this. I have property in the town center business district. None of us were given notice. And my distinguished alderman, Mr. Wood, right, okay, from the second ward, he was very clear, I think in 2019, before the city council, to make sure that the town center business would be a part of this process. And I believe it has been. If I'm reading the current code correctly, you can develop or redevelop a lot in the town center business with 40 feet of frontage. So if you have a 50-foot lot and you want to knock your building down and build something else, you can do that. But now, under the new code, you're going to have a 100-foot lot. So if I'm wrong, correct me on that. So, I mean, that's extremely important. And none of us were given notice. Nothing whatsoever. So I think that in and of itself violates due process. And all we're going to end up with, if you let this thing go through, is litigation. Now, if I could ask Gosha a couple of questions. You're the planner.
That is correct?
Do we have a community development department director?
No, not at the moment.
Okay, we don't have one. How many full-time employees do you have in your staff?
Oh, I have to do the math. 1, 2. I believe it's 4.
4. How many part-time?
1, actually 2, 1 intern.
Okay. What I don't understand is why do we need a 243-page zoning ordinance? You heard Mr. Zubak talk, and he talked very eloquently about, maybe some of these businesses would just go somewhere else. Well, let's look at the other businesses. Let's look at the 2020 census. The city of Wooddale has a population of 14,000. We don't even occupy 5 square miles. And yet, we have a current zoning code with 92 pages. And my research discloses we have at least 6 lawsuits that are arising out of that particular mess. The proposed ordinance is 141 pages, or 241 pages. You add on to that the building code at 35 pages, the commercial occupancy ordinance, which I don't even think the city has the authority to pass, but they did, you end up with 307 pages. All right, let's go to Bensonville, to our east. 18,000, 5.6 square miles. Zoning code, 45 pages. Elk Grove Village, to the north, 32,812 people. 11 square miles, I should say. Zoning code, 60 pages. South to Addison, 35,000 population, 10 square miles. Zoning code, 21 pages. City of Chicago. Now, if we want to really compare with something, let's go further east. The city of Chicago has 2.71 million people, occupies 234 square miles. Their code is 241 pages. How many people do they have working in that department? 150 full-time people to process that code. And we're going to pass something that's 243 pages and dump it on people, 4 full-time employees? It's insane. Now, the two gentlemen sitting there are brilliant. I know that. I can tell by reading what they wrote. But we spent $129,000 to come up with this, when really the goal should have been, let's get this as small as we can. Let's get this to where people can actually work with it. What troubles me is, us as the small business owners, we didn't create these lots, the city did. So you created these lots, we bought them, we built businesses on them, and now you want to run us into the ground. That makes no sense whatsoever. And when you talk about this legal non-conforming, which I understand it runs with the land, if someone is going to stay in their home that may be now legal non-conforming on Irving Park Road, and they leave it to their family, and they leave it to their family, and it goes on and on in perpetuity, it's never going to get redeveloped. So what's the point of that? Well, we've heard some talk about the comprehensive plan, which is from 2018. One of the things that was mentioned in there that no one else mentioned is strategy. Work with owners on remodeling and expansion options for existing commercial buildings. So why aren't we focusing on that? Why aren't we focusing on the people that have put their blood, sweat, and tears into this community, built up businesses, built them up with the idea that they would have equity in them, and that you would help them either to pull their equity out of it or help them to expand. Now, the first letter, I believe we would call it a fee engagement letter, or the first proposal, scope of work. And if I could ask the two gentlemen about it, more quickly, if I could find it. You said in there, you would meet with customers. We will meet with local businesses, architects, designers, and engineers. We would meet with local businesses, small and large. Can you name the small businesses that you met with?
It's been a while, I really can't recall
You
exactly.
don't know.
who we met
Well, you know what, that's something pretty important. I would think I would remember that if I actually did meet with small businesses. If I met with you and I knew that you were in favor of this, I would know your name. Did you meet with any appraisers?
Again, it's been almost 2 years, I honestly don't remember who
Did
we
you
met.
meet with any-
Mr. Trotto, I'm just going to interrupt you here.
Was that?
Tonight, we're here to talk about the proposed amendments. Do you have any questions specifically about the amendments that are being proposed?
I would.
I understand you
add-
have questions
Okay,
about
I
their
understand that,
engagement.
sir, I really do. But you didn't give me notice, okay? I'm lucky I found out
Do
about
you,
this.
do you have any more questions about the proposed amendments?
About the proposed amendments? Yes, I think
yes.
that you should
Okay.
deny them, okay?
Okay.
And I think that you should send us all back and start over again. Thank you.
Thank you. Okay, is there anyone else here who has not spoken yet at any of the meetings that we have had? Mr. Latoria, I know you have spoken. Sir, have you spoken at a meeting yet?
I have not.
Okay, obviously you have a comment. You take the podium.
I do have a comment.
Okay.
I'm not an attorney.
That's okay. We'll just go.
Emmert, E-M-M-E-R-T. 310 Elmwood.
Would you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes. We also didn't receive notice to our legal address. We're a renter. It's a residential building, and we're trying to understand why it's being rezoned. My wife's been here all 4 nights trying to get answers from this commission, and we don't get anything answered. We'd like to know why a property is being rezoned, and we're not asking for it. We're being forced to move into a different position on a property, and like everyone else is concerned about, it's changing the property, how we can use it. We're wondering why this is. As for the notice, I believe we should have the signs. We should let the neighbors in the neighborhood know what's going on across the street. None of my neighbors got notice. They don't know what's going on. That's about all I have to say. I think you should not pass this, readdress it, rewrite it, do it right. I think Anthony did a wonderful job of introducing his fact and the fact that you cut him off when he's trying to say he didn't get notice. He should be able to talk. That's what this is about. No one wants to listen to our side of it. You're just going through your process. I'm not an attorney. I'm just a resident. I'm trying to figure out what's going on. And there's been no answers throughout this whole thing for us. That's all I got to say. Thank you.
Thank you, sir. Thank you.
May I?
And Ms. Boche, did you have a follow-up to that?
Yes, I'm sorry, thank you. So I actually, I was contacted today by actually the tenants of 310 East, so I apologize, we never got a chance to discuss this. So the notices, just to address that, the notices are always addressed to the property owners, not necessarily the tenants, because ultimately it is the property owner who owns the property and has the legal right to it. So the notice was sent to the property owner, not the tenant. And in terms of this particular property, it is on Elmwood, but it's already zoned commercial. It's zoned C1, and the proposal is to rezone it to TCB. So it is commercial, it will remain commercial. And the main reason for that is just for consistency with the surrounding zoning district. The entire area and the proximity of it is within the TCB zoning. So this is just,
Thank you. Okay, is there anyone else who has not made a comment that would like to make a comment at this time? Yes, ma'am, please approach the podium.
Mr. Conway, or Counselor, I haven't spoken at any of these meetings yet. I have not.
No? Okay. Oh.
Okay, thank you. Just one quick question.
Would you raise your right hand, please, and state your name and address? Okay, and do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
I just have one small question. On the current zoning, there's a little section here called R4 that you're changing now to C2. I just want to know if that residential parcel is the parcel that the city bought and now is going to be looking to redevelop the two houses behind the Helen's Deli. Is that what this property is, R4?
Okay. Ms. Bocheha?
yes, that is correct. Those are two parcels that are currently zoned residential. They're proposed to be rezoned to C2. The City of Wooddale is the owner of both of those parcels, and the single-family homes have been demolished, so they're vacant right now.
Right, so are they demolished and now you're looking for this rezoning, all this other rezoning to get your property, the city's property through to make it commercial?
Yes, yes, because the two properties that are on Irving Park are zoned C2, so this is an expansion of that commercial zoning district to include those two properties.
Could you have done this rezoning just for your two parcels and not bother any of our other?
I mean,
I'm trying to figure this out. Is this an end game for the city
so
to get your two parcels to a commercial?
no, so definitely that could have been done on its own. Really, the purpose of this meeting and of this process is a comprehensive rewrite of our zoning ordinance and rezoning of properties that kind of fall in between. A lot of this was really driven by our comprehensive plan and the direction that was given at that time. So it's not really meant to sort of target just specific properties that a city owns, no.
Okay, well, I oppose it. You object this proposal.
Thank you, ma'am. And Mr. Latoria, my apologies, I thought you had testified, but please take the...
You don't have to apologize to me. At least, not yet. Mrs. Geppetta, how are you?
Tired. Would you raise your right
Oh,
hand,
sure.
Mike, and state your name and address, please?
Mike Latoria, 355 East Potter Street.
And do
Wooddale.
you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Mrs. Chapetta. So I've been sitting here for 3 nights, and I've heard, and I'll keep this real short, and this is not adversarial, and I'm not coming here to bash, and I certainly don't have the wherewithal to match wits with the consultants that are sitting here, and I'm actually dieting, so if I say anything that offends anybody, just let me know, because I'm a little lightheaded. Summer's coming. I'm hearing we have to protect the houses, we have to protect Wooddale, we have to make it easier for Wooddale and staff to get things through. I'm not hearing anything about the businesses being represented, all right? Nobody's representing the businesses here. This is our opportunity to represent ourselves. And Counselor, I get it, how you're cutting off my attorney that I'm paying to vet 248 pages, and I understand how you're cutting off other people because I don't want to be here either. You guys don't want to do this, I don't want to be here, right? Nobody wants to deal with this. Boring stuff, dotting the i's, crossing the t's, all that kind of stuff. But the businesses are here. We're the ones you come to when you want help with your fest, your train station. Who do you go to? Who do you? I got less money to give to your fest this year because I'm paying my attorney to be here, to vet this out, to figure this out. What if my attorney wasn't here? What if the other attorneys weren't here? Would you be having this conversation? Would you turn it down? There's been some stuff that's been brought up. Mr. Blue agrees that there's some mistakes. Not a lot, Mr. Blue, but there's some mistakes in here that you guys are correcting. Marshall gave you a memo. I'm sorry, Mr. Silverman. Mr. Silverman concurs that he brought up some good points. What if he wasn't here? What if we didn't hire him? Now, there's a couple people on the audience that are selling themselves short. Brian Paul owns Premier Design Build, all right? They build the great big buildings that you guys are looking for. The ones you love, the 100, 200,000 square foot buildings with Transwestern and Bridge Development. He's the builder. National builder, right there, telling you it's a bad idea. I can sit here all day long and cry about Potter, but I'm not making it about me. I'm talking about Wooddale, right? Gulu International, national builder, national developer. His counsel's here telling you it's a bad idea. If you can't go home and explain this to myself, right? If I can't go home and explain this to my wife, she's a 3rd grade school teacher, this can't be explained. This doesn't make any sense. So what I'm begging, what I'm asking you to do, postpone your vote, bring the businesses, the mom and pop shops, the people that make Wooddale what it is, on top of all of you, right? Bring us to the table. Give us a seat at the table. Let's talk about it. Let us help you make Wooddale better. We're in. We want Wooddale better. If Wooddale's better, we're better. You're better. The residents are better, right? Give us a seat at the table. Bring us in. Do not vote for this. There's people out here that do this for a living. Please, do not vote for this. Thank you. And thanks for your volunteerism.
All right, thank you. Is there any other member of the public who has not spoken at any of our meetings yet? Okay. Are there any questions that the CDC members have of staff or the consultants at this time? This is the time to ask any remaining questions that you may have, because once we close the public hearing, the next portion will be for your deliberations only. You won't have the opportunity to ask the public or the consultants follow-up questions. So any remaining questions that you may have at this point, now is the time to ask those questions. Yes?
Yeah, first of all, I mentioned it last meeting. I want to thank again Attorney Subak, Attorney Carmelucci, and Attorney Trotto for your comments they're appreciated. Some of those things, you know, we may or may not agree with, that's an individual thing. But when I went through Marshall's list of what it was, 18 or 20 things, I had a lot of notes. And then when I got the memorandums from Mr. Blue and Mr. Silverman, you did a great job on that. So I appreciate that. That solved a lot of the questions that I had. So I want to thank you also for responding to that. There's, in your notes that you mentioned, I believe, Mr. Silverman, that the city council would have to make the policy decisions on a lot of those things, and I think that's good. The question is, you know, where does it go? I guess I'm still puzzled. I would like to hear from more people. I know there's a couple gentlemen over here that did speak before. Are you satisfied with what's going on? No. Would it be possible for them to ask the consultants while they're here, their concerns?
Would you like some follow-up testimony?
Yes.
Okay. So are you gentlemen wishing to provide some follow-up testimony?
Here's what I'd like to know. I know.
Okay, hold on.
Okay.
If they're going to provide follow-up testimony, then they'll need to approach the podium. Okay. So, sir, would you like to make some follow-up testimony? Okay, can you please approach the podium? Only because this is being recorded.
I understand.
So I want to make sure it gets into the microphone.
Would you raise your,
Bruce Larson.
would you raise your right hand, please?
I've been sworn in a couple of times
Oh,
already.
you were, then you don't need to. Bruce Larson, thank you.
All right. Once again, I can go into a lengthy personal plea, but I'm going to pass that up. I made a lot of notes that they did respond to in responding to Mr. Subak's questions. I do still have exception to Mr. Blue's characterization that he made broader, more open permitted uses, when all of the permitted uses that they did put there were taken, transposed word for word from the existing permitted use table. They're not more general, broad, they're just more restrictive. I'm going to ask the commission once again to continue this meeting, this published discourse, until the next regularly scheduled meeting, as we are having pertinent and relevant information prepared by unbiased professional consultants, which will not be available until after May 1st, which I believe will better inform the commission members prior to their recommendation for this proposed UDO. The last thing I want to ask is, when this goes before the city council, after your vote, is there a notice that's sent out in that, or strictly just the agenda that's published on the internet and posted in the lobby?
So the process is, if there is a vote tonight, it will go to the next PZB committee meeting. And I believe staff has that date for you. So that
PDB?
PZB, the Planning Building Committee. So that will go to their committee meeting. They will consider the proposal. They will vote on it. And then it will go to a city council meeting. And staff can provide you those dates.
Yeah, so the next PZB meeting, I believe, falls on May 12th, which is a Thursday. The meetings are at 7:30 p.m. And the following city council meeting, I believe it's the 19th of May, which is also a Thursday, also at 7:30. So these are just the regularly scheduled meetings. Obviously, it depends on the outcome of tonight's meeting and the availability. The decision on the city council meeting will be made during the May 12th meeting.
As a last thing, I'd like to once again pass out a letter that I wrote to you commission members. And I hope you take the time to read it. All right then?
Yes, you can pass it out, sir.
Thank you, Mr. Peterson. Larson, sorry.
Hey, Mr. Larson, is this the same letter that you previously?
No, it's not.
It's a new one? Okay.
No, more required reading. Stuck together.
And Member Babowitz, did you have any follow-up questions for Mr. Larson?
What is your, what, if, in
Hold
a couple of
on.
words, what's your main
Mr.
objective right now?
Mr.
Did-
Babowitz?
Yep.
We will need him to go to the podium.
Oh, sorry. My question is, you know, with our two consultants here, is there a specific question you have of them? Because they're here now. And they can, I mean, they can probably answer your question. And hopefully,
I don't, no, I don't have a specific question for them. I haven't read the entire UDO, to be honest with you. I restricted myself to reading the sections that applied to changing my building from a conforming use with 121 permitted uses to a non-conforming use, which, in my opinion, is lowering its value, lowering its usefulness. We won't have the money, we won't invest any money in maintenance or upkeep of that building. Perhaps it'll become abandoned. That's my concern. I don't want to become non-conforming. I want to stay with what we have. The building my grandfather built in the early 60s. The taxes that have been used throughout all those years to develop Wooddale. I want a return on my investment.
would the consultants have any response to that?
Nothing specific.
Okay.
Thank you.
Thank you, Mr. Larson.
You were sworn in. Your name again, please?
Roger Dickens.
Dickens, thank you.
Jay, it seemed like you might have had a direct question for me. I wasn't sure.
No, I'll tell you what happened. I believe it was last meeting, you were not happy with what was going on.
Well,
Well, let me just finish. And I wanted to catch you, and I should have done it when you were at the podium, and I didn't, and I noticed you had left early, and not a problem. But what specifically, again, do you object to? And hopefully our consultants may be able to make you feel more comfortable. I mean, a lot of the things that have gone on here in the last few weeks, they have detailed what's going on, and it's not as bad as you think it is.
well, and I agree to that, but what I kind of have a question for right now, and I think that a couple of people said some things without possibly articulating exactly what I think they meant, because there's a lot of hot passion here. I'm in a unique position, but like I said, we use this as one of our offices, the smallest that we have. But as Latoya had said before, you have such wonderful people here that you could be reaching out to for business development. I mean, for me, Wooddale is, like I said, I go to other countries and help develop. But it's never been rushed out to us to help the city in that direction. You have one of your best builders here. You have all these people, all this talent right here, but we don't utilize it. So for me, yeah, it's okay. Stay at this building, don't stay at this building. Sell it as this, sell it as that. I'm here because I want to be, because it's been our family's building for so many years. But at the end of the day, if my daughters go somewhere else, it's going to be all right. I think that what we're seeing right now is, instead of making us part of the solution, you just kind of made us the problem. To where if your consultants would have said, what do you suggest, how should we do this, how can we properly develop this better, to increase everybody's long-term goals, that's a much easier sell than pushing things down our throat. Right here, I mean, these guys, people that actually have passion about this and care. I mean, it seems like you guys have good intentions, but good intentions without a proper plan, they fail. And it doesn't mean that Wooddale's gonna fail. Doesn't mean that this is gonna fail, because you can push it through. But what it means is, you have an abandoned town to where instead of having Itasca, you have Bellwood. That's not what you want here. That's not what you want for your community. With the way things are going economically, food sustainability, none of that's been brought into this. Anything for education to an education center, there's so many different things that could be brought in to the city and town, hasn't been done. And I just think that if you utilized us as your helping as a community, we could further better ourselves. And that was the point that I was trying to say, because if the gentleman wanted to reach out, I'd be more than happy. I'm sure anyone here that is a specialist in their fields would come in and help. Has any of that been thought of? I mean, helping the community, there was a time where you would reach out and you would buy as simple as sanitizers from us, or if you were gonna have a project done, you would call him. If you were gonna have, you would reach out to us and we helped each other as a community. We don't do that anymore. Not in Wooddale. Other towns do. Other states do. But I have learned to accept it, and whatever I do for the city of Wooddale, I do it with the goodness of my heart, and realize that those things will never be reciprocated. I think that it's a sadness in the community. But I'm sure others have to feel similar about that. Is there anything, I mean, why not reach out to the people to help? Sir? Why not reach out to us as a team to help further the goals?
This does. Oh. Sorry, again, we'll do as we're requested by the city.
All right. Thank you very much.
Sir.
Have a wonderful day.
Thank you. Okay, are there any members of the CDC who have any questions of the consultants? Yes. Okay.
Gosha, my question is, after hearing this for all the nights that we have, do you think it would have been a better idea to send out all the notices, one, and to have more people on that steering committee?
As I think this could be a hypothetical question, yes.
Your opinion.
Oh, my opinion. So we talked about the UDO steering committee. This wasn't a decision that I was involved in personally. I think.
Your opinion.
My opinion? Always. As a planner, as a certified planner, yes.
That's what I wanted to know.
Okay. Any other questions that the CDC has of the consultants or staff? Okay. Again, this is the time to ask any remaining questions.
Well, this is for the consultants. You guys are professionals. You do this all the time, more than anybody in this room, or in the council or anything else. I'd like to hear from both of you where you think we are right now, where you think we should go, and what should be done in and all, and I know you'll do it honestly.
You've heard a lot of testimony from property owners who are directly affected by the changes we have proposed in the draft. We have done our best to respond to those concerns. I really need to turn this back around on you, because you now need to consider the thoughtful comments that have been delivered by these property owners and others over the last several nights. It's not an easy task.
Absolutely.
You guys are the gatekeeper to the code. And City Council has put the responsibility on you to thoughtfully consider everything you've heard based on what was proposed, based on the direction that we received. And I do want to emphasize that this process goes back to 2018, with about a year and a half interruption, where we did in fact meet with business owners and property owners like Michael. I couldn't recall who they were, because it was at the very outset of the process. Staff helped us identify property owners who had concerns about how the code operates and the effects of the code and the processing of applications and things like that. We considered those things. We considered what you had. We tried to build in best practices, clarify language. This is not an easy process. It's not an easy process for us. It's certainly not an easy process for property owners who are going to be affected by it. We may have sounded dispassionate. Frankly, Michael's been a little bit more passionate than me. I'm an attorney. Accuse me accordingly. But the fact is we did the best job we could for the city of Wooddale. And we think what we have provided, and we tried to be as thorough as we could, for instance, to Mr. Subak's itemized list. We thought very hard about it. We gave our views on it. In some instances, frankly, we punted it back to you. But that's your role. And we have just delivered what we thought is the best possible solution for the city. So, as I said, we have to kind of turn this back around on you. We have done everything we could do. We take our direction from you. You have to make an informed recommendation to City Council. That's what they're expecting you to do. And that recommendation should list out proposed amendments based upon the things perhaps you've heard here, or whatever. Or completely deny it and let City Council deal with it. And as some of the people have suggested, it could be sent back down to you for further consideration. That's where we're at. I can't help you more than that right now.
Do you think there's more work to be done?
I don't. I mean, I think there may be more work to be done when you look at it, consider it, let us know how you want to proceed. Or you make your recommendation with any revisions to the text. City Council takes it into consideration and they might task us to make those changes. Again, we work for you.
And you've done a good job. Don't take this as criticism.
No, I'm just trying, you asked this very
It's a
particular question.
big job.
Yes.
And, not everybody's going to be happy with the decision you make.
That's right. That's right. Whenever you're taking a document of this scale, there's going to be a lot of pressure points.
Michael, you had
Yeah, you said we both had to answer, and I made the mistake of letting the attorney go first.
Well, you got it.
I would just add a couple things, and I agree wholeheartedly with everything David said. I would add a couple things. One, this is why you have a public hearing, right? This is why you have this process. This is why there's notice, and I understand there's confusion or problems with it. I get that, but the room's been full for 3 meetings, and that's why you have these meetings, is so that you, as a CDC, can hear what people have to say about the draft that was prepared. Right? That's testimony. You all, just like you're hearing a case from a zoning application, right? You take all this as testimony and decide what's the best action for the city of Wooddale that you've been charged with the recommendation to make to the city council. Everything that comes before you can go, we could have done it this way, we could have done it that way, why'd you put it there, you could have put it there, right? And so everything goes like that. I would echo what David said. This is not an easy decision, this is not an easy call, but that's why we have this process. This is part of the process, and folks have taken advantage of it, and I appreciate and respect everything they've said. But it ultimately comes down to what's the direction that the city is going to take. You'll make a recommendation, and the council will act. And if we're looked upon to do something differently, as David said, we're here to work for the city.
Thank you for your effort. Appreciate it.
Okay.
That's all I have to say.
Are there any other questions? Yes, ma'am. Wait, is this an addition to the testimony that you've already provided?
Well, when I came, I thought I was going to be able to hand out something to you.
Okay. Yeah, do you have a handout for the commission?
It was going to be to you.
Okay, yes, we'll accept that handout.
And I'll say the reason why is because I didn't realize I could hand something out to you guys.
No,
Should I hand it out to you?
yeah, just hand it out to us, we'll make it part of the record.
Thank you.
My focus sort of has been, because mine was downzoned, and I was right at the process, I don't want to take your time, but I was right at the process of listing my property, and then my agent canceled. So what I included here is just how the property, the realtor said everything is getting better because more people are renting industrial properties. And so I highlighted, one thing he brought up is about the construction costs. So for someone like me that's a smaller building, it's very expensive to try to rebuild. And so that's one point I wanted to make. And then my emails that I talked about where my realtor canceled, I included that. And then I had what was the possibility of what's going to happen at my property. And then I talked about the trees. I do want to, I'm going to tell you guys, I would rather you not vote for this to go through right now. Let's talk about it a little bit more, because I would like to see, somebody mentioned at last meeting about doing an overlay. And again, I'm not an expert, so I may have this wrong, but my understanding is maybe you can give it to us so that we can sell our buildings immediately if that's what we want to do. And the new buyer could use it as an industrial building. And then in the future, if that particular new buyer wants to do what you guys want to do, which I think is good, what you're trying to do, it looks beautiful, they could then work with you guys easily to redevelop the property. So I'm just maybe one of the people that has more of an immediate type of issue going on. So that's why I would ask that you not vote okay on it, for that reason, to maybe have an overlay is what I understand. So.
Okay, thank you, ma'am. Okay, any further questions on the CDC? Okay. All right, so at this time, there being no further testimony, it would be a motion to close the public hearing in this matter. Do we have a motion?
I'll make that motion.
Is there a second?
Second.
Okay. And Marilyn, roll call, please.
Okay. Mr. Ochoa.
Here, yes.
Mr. Babowitz.
Yes.
Mr. Peterson.
Yes.
Mr. Surma.
Yes.
Ms. Zadko.
Yes.
And Mr. Woods.
Yes.
Okay, so the public hearing portion of this matter is closed, and now we proceed to deliberations. So this is the part of the meeting where you have the opportunity to discuss all of the issues, the pros and cons that came up. What I would like to do, just to sort of get the ball rolling for you all, I believe there's sort of like a grouping of issues that I think that you'll need to address. The first big issue is the proposed table of permitted uses in relation to the proposed C1, C2, C2A, and C3 districts. We've heard quite a bit of testimony on the proposed uses in the C3 district specifically. So that's a larger issue that I think encompasses a lot of the individual issues that came up through the hearing process. The other larger issue that I see that came up is the proposed non-conforming regulations in Article 7 related to the sale or lease of non-conforming property and the impact on property values. We've heard quite a bit of testimony on the concern that making a property legal non-conforming would have an adverse impact on property values. So that's a big ticket item to consider. The other bigger issue that we heard quite a bit of testimony on is the proposed Thorndale Interchange Overlay District. I believe it was the attorney for Mr. Gullo, or the Gullo properties, And his concern was that this proposed district may be too restrictive. So that's a considerable amount of testimony we had on that. I believe Mr. Subak submitted some testimony on the proposed list of authorized variations. And I believe the general tenor of his testimony is that it's, right now is written, or as proposed, too restrictive. There was also some testimony about proposed definitions, such as the definition of a junkyard. So those are the major items that I saw come out of the hearing. Obviously, this is your time to talk about other issues that you feel came out of the hearing. There are, just to kind of give you your menu of options as you consider this and then ultimately vote on it, like the consultant said, you can, when this is put to vote, you can vote no. And it would be go up, and if that's the majority, or if we get 4 votes of no, that would go up as a recommended denial of the entire amendment. The other option is you can vote on the proposal, but also suggest that the city council examine some of these bigger issues that came up. So, for example, it would be a motion to approve with the condition that the city council examine, for example, the uses that are set forth in the C3 district, or the uses set forth in all the C districts. And, you know, you could do it that way as well. Or you could do a straight vote to approve what was proposed, just as is. So there's a number of options there for you. And so now I'm ceding the floor to you to sort of discuss what are some of your concerns or suggestions. Mr. Wood?
See if anybody else has anything to say first.
Well, my feeling is, I think there's still work to be done. And I was trying to get that out of Mr. Silverwood, but he didn't give it to me. I think there's work to be done yet. I guess we could turn it over to the city council. I know 8 of the 9 representatives there, and they're all, they're very intelligent, smart guys. They'll do a good job. But I don't know if that's what I want. I'm still puzzled. I really am. I guess I just think there's work to be done, and I don't know whether we get together as a group. You know, none of us are experts in zoning, like these guys or the attorneys. I have a bachelor's degree and a master's degree in business. I took some law courses, but nothing in zoning. It's all business management or business law. You know, I'm not an expert at this, and to think that I should make some of those decisions, I think is wrong. I think I have to rely on these other guys, in my opinion. And I will make a decision and hope it's the right one, but I also feel for you people out there. If that were my business and I wanted to sell it, you know, we all want to make money no matter what we do, right? We buy a house, we hope in 20 years when we sell it, it's worth a lot more. Or if we buy an antique car or coins or whatever, we hope that it's all worth a lot more. But when you have a concern, that's my concern also. And I guess that's all I have to say.
There is some work that needs to be done. A lot of questions and concerns and issues were made aware, and responses were given. A lot of clarification was done. And there, as Sean expressed, there is some remaining issues that need to be examined. And it needs to be done at the right level, I think. I want to say that you know who your aldermen are. You know how to reach them. You know how to get their attention. And I want to hope that you're going to do so in the immediate future to express your concerns as you share them with us here today. So it's hard. It's going to be hard to make everyone happy when we have something this huge to vote and share our opinions and feelings and experience and knowledge with. So with that, there is some work to be done, and let's get it to the right people.
I agree, there's work to be done. In fact, a lot of work that needs to be done. But let's start with putting it to the right people, the people who should have been on that committee to start with. I mean, they weren't even notified. How can we kick it upstairs when you have probably 98% of the city never even knew about it? I mean, you got to give these people a chance to come in and voice their opinion. These people came in just by hearing things here and there, and other ones talking to each other. And as you said yourself, you would have had more people on that committee if it were up to you. You would have sent out the notices if it were up to you. I believe it should have been that way. There's no sense in sending it to committee if they're going to end up having to send it right back down to us. All you're going to do is waste more time. I think we are started in a good direction, but it does need a lot of work. And you need to get people from the community involved to fix that work. That's all I got to say.
I want to say there is a vision. I can see the vision, as some of you can see the vision also. And maybe the people that got this ball rolling need to share that vision and do a better job of sharing that vision with you.
It just seems like there's an awful lot to be absorbed here. All this paperwork was dropped on me last week. And we still got some more today. I think we need more time to comprehend all these things.
Okay. Any other comments?
What if another steering committee was put together by maybe some of the people here, some of us, whatever, to kick this thing around, unfortunately, one more time? You know, these guys have been vocal. Some of you have been here every meeting, and it's appreciated by me, I'm sure by everybody else, because it gives us an insight of what's going on. And nothing against you guys. You know, you got a huge job, our consultants. Please, you know, whatever if you think I'm against you, I'm not. And I think it was time to probably get this thing done, because I understand there were a lot of confusion and a lot of lawsuits. That's what I heard. Whether it's right or wrong, I don't know. So by doing it is the right thing. By doing it wrong is the wrong thing. So my proposal is to put together another steering committee, and I don't think it's 4 or 5 or 6. I had 10 or a dozen people, and more if we need it, and get the input from not only the people that have been here, but there's some people out there that either are confused or, from what I'm hearing, didn't get notices or just found out about it a week ago, as this gentleman here. We need to get those people involved. Let's hear from the community. This is a great town. You know, I'm retired, and everybody thought I was going back to Wisconsin. Well, I'm not. I love Wisconsin, but no, I'm not. I love Wooddale, and that's why I sit on this committee, and that's why I'm concerned with what's going on. So I realize we can't make everything right for everybody. It's never going to happen. And if this is the only group of people that are upset and everybody else is happy, you know what? We should pass this thing tonight. But I don't think that's the case. So I propose putting together another steering committee, 10, 12 people. I'd also like to get, and I don't know if we can do this or not, I may not be able to do it, get 1 or 2 aldermen in on this thing. Let's hear their side, what they have to say. Art, I haven't asked you any questions, and I won't tonight. But I'd like to hear from a lot of people. Let's get a group, you know, let's get a good sample size. Being a marketing guy, you know, that's important. You want a good sample size. I don't think we have that yet, but I think we can get there.
And Member Babowitz, thank you. In terms of forming another steering committee, that would be the prerogative of the city council. if they so choose. It certainly can be something that you make a recommendation to the city council in voting on this, that if another steering committee is prudent, that you would recommend it be formed. And so that could be made part of the motion tonight to recommend to the city council.
Yeah, I'd also like to hear, do the rest of you think, where are you guys at on another steering committee? Do you think that's, we should do it?
Well,
I agree.
I think if the public were notified of the steering committee to begin with, we could have avoided a lot of these issues we had from the start.
I think we have some concerned property owners out here that, as mentioned before, are probably gonna contact their alderman, right? Out of maybe a raise of hand or a nod of heads, how many people from the audience would be interested in being a part of something like this? Well, as you contact your alderman.
That's terrific.
Right? Maybe
Don't leave yet.
you vocalize your intentions or what was discussed here.
Okay. All right, any additional comments?
I'll even pay my attorney to go there. They had to get the Chamber of Commerce involved. They didn't know anything about it either. Sorry about the public testimony. I know it's over.
Okay, any other comments of the CDC before we proceed to a vote? Okay, so based on sort of all the comments that I've heard tonight and all the testimony that we've heard about the various issues, there is a recommended motion in the staff memo. I am going to modify that to fit some of the things that I've heard tonight. It's lengthy. If you are in support of this motion, you would vote yes. If you are against this motion, you would vote no. Okay, so I will propose the motion. If you have questions about any aspect of the motion or what it means, please ask me before we proceed to vote. Okay, so here is a motion, and somebody can say so moved after I get through it all. It is based on the submitted petition and the testimony presented, the proposed comprehensive rewrite of the Unified Development Ordinance, Chapter 17 of the Municipal Code, and rezoning of certain properties are consistent with the comprehensive plan, are in keeping with the purpose and intent of the UDO, are in promotion of the health, comfort, safety, and general welfare of the city's community. And therefore, I move that the Community Development Commission adopt the findings of fact included within the staff memo dated April 25th, 2022, as the findings of the Community Development Commission, and recommend to the City Council approval of the comprehensive rewrite of the Unified Development Ordinance, Chapter 17 of the Municipal Code, and rezoning of certain properties with the additional following recommendations: that the city's PZB committee and/or the City Council examine the following. 1, the proposed table of permitted uses in relation to the proposed C1, C2, C2A, and C3 districts. 2, the proposed non-conforming regulations in Article 7 related to the sale or lease of non-conforming property and
Sean,
any impact.
Sean, excuse me, just 1 minute. Would you start that second one again, please? Proposed
2,
non-conforming.
the proposed non-conforming regulations in Article 7 related to the sale or lease of non-conforming property and any impact on property values. 3, the proposed Thorndale Interchange Overlay District. 4, the proposed list of authorized variations. 5, the proposed definitions, such as the definition of junkyard. 6, to examine whether another steering committee is prudent.
Okay.
So that is the motion. And again, a vote of yes is in favor of this motion. A vote of no is against the motion. Okay, any questions on the substance of the motion?
What if you like some part of it, not other parts?
Well, we'll vote on this. What part don't you like?
Well, what I don't like is the steering committee.
Well, let's do this.
Okay.
What we'll do is, we'll do a motion and a second, and then we'll have discussion on the substance of the motion. And if you want to make an amendment to that motion, you're authorized to make an amendment. Okay? But any just questions on what the motion itself means?
We can't put it in our own motion?
Well, you would do this one first, and then through discussion, we can amend it. Okay?
Okay, we need somebody to make that motion.
So, recommended motion as stated by city council, so moved.
Okay, is there a second? And this is just to get it to the floor for discussion.
Second.
Okay, there's a motion and a second. Okay, now is discussion. Is there any aspect of that motion you'd like to change or amend?
I'd like to make it that the steering committee is not up to somebody to make a decision whether they want it or not, but it's definitely there. And Teresa, you mentioned you'd like to hear from more people. I agree with you 100%. I'd like to see, those seats filled with some new thoughts and ideas. As I said before, if all this is just about this group here, then we're doing the right thing, because you can't please everybody. But if there's 10 and 20 and 30 people behind each one of them, then we have a problem.
So just as a matter of procedure, that's not the steering committee is definitely something that this body can recommend to the city council. It is not something that this body can impose on the city council.
Okay.
So it's certainly something you can recommend, and this motion recommends it. But it's just not something within the purview of this body to impose.
Okay, let's say that we recommend it and they are against it. And I voted for the amendment. Now, I want the steering committee, we don't get it, and I voted yes. My ass is hanging out.
Well, ultimately, you have a prerogative. You can vote no to this motion. Okay, it's absolutely your prerogative. You can vote yes, you can vote no.
And you're also a resident, you can talk to your alderman. Right.
Yeah.
Are there any other suggested changes to this motion that's been proposed?
So you want a roll call?
Okay, any further discussion? All right, roll call, please.
Mr. Babowitz,
No.
Mr. Ochoa,
Yes.
Mr. Peterson,
No.
Mr. Surma,
Yes.
Ms. Zadko,
No.
and Mr. Woods.
No.
So the recommendation of this body will be what's called a recommended denial. So it will go up to city council, will go up to committee and city council as a recommended denial from the CDC. When it goes up to committee and city council, they can accept the recommendation. They could not accept the recommendation of the CDC. Ultimately, the city council is the final decision maker. But Gosha, can you give us the dates of the of the meetings again?
Yes, so the next scheduled PZB meeting, so this is Planning, Zoning, and Building Committee, is scheduled for May 12th. It's a Thursday. The meeting starts at 7:30 PM, and it's in the same room.
Coach, would you consider moving that to the following meeting?
It is not something that I typically schedule, so it would be up to the administration to make that. I believe that is the next available meeting, so typically the CDC cases move to the next one. Next scheduled meeting. That's the next one that's on the schedule, to my knowledge.
What is the process to get that steering committee on record? Is that through GOSHA or?
Again, that's a city council decision.
But I mean, you said I could send a letter.
Yeah, so, well, and this is all recorded, Member Gavowitz, so
So is it
you'll be
done?
able to watch this recording and
Okay,
get your
so is it,
suggestions.
so do they know about it? Art? No, really, if there's something I need to do, I'll do it. If not, and it's automatic, that's fine.
Yeah.
It's automatic?
Right, staff will be in communication with administration.
And then somebody will get to me to say it's gonna be done or not done or whatever?
So ultimately.
I'd like to know what's going on.
Sure, the meeting minutes from the Community Development Commission always move on to the PZB, so they have a record of what happened during the public hearings. So ultimately, that is the process. We have the public hearings to hear the public, get the testimony, everything gets summarized as it moves on through the rest of the process. So that definitely will be conveyed to the Planning, Zoning, and Building Committee. But I can certainly let, during the probably next CDC meeting, which is scheduled for May 16th, I may have an update depending on what happens at the May 12th meeting.
And if that committee does get together, certainly we'll give our consultants all the information, unless they want to be there to help this thing along. Again, I don't want you guys to think I'm not on your side, because it's a hell of a job, and thank you. And also to the attorneys.
Gosha, are CDC members, committee members allowed to go to this PBZ meeting?
It's an open meeting, yes, anyone is allowed to.
So,
Let me know. Yeah, go.
Thursday, the 12th.
Okay, you be there? I'll be there.
I'll be there.
Ready to go?
Yeah. Well, when you say ready to go, I don't know what you mean, ready to go.
Aren't you a Marine?
I'm not a Marine. I'm better, sailor.
Sailor? Oh, my God.
Okay,
But
so
I'm gonna sit to the side.
that vote completes this matter, and Mr. Chairman, I will cede the floor to you for the remainder of the meeting.
Okay, with that, we'll go back to staff, and for any staff reports.
So the only thing, we do have a petition for a different application that was submitted to the city, so we do expect to have a regularly scheduled CDC meeting on May 16th. There's the one petition that's coming up.
So, okay, Mr. Conway, as chairman, request that we...
We're moving to adjournment.
Yeah, there we go. We need a motion to adjourn. Can I get a motion, please?
Make a motion to adjourn.
Can I get a second, please?
I'll second.
All in favor? All in favor? Yes. Motion carried, meeting is adjourned.